Hi, on the phone that says owner. Who are you?
Lakeisha Payton.
What case are you here for?
It says, I'm sorry, 1 second. I can't see my paper. It says for David John King.
Okay, that's the attorney. Do you have a case number?
Case number. I believe it's 225403.
225. Lakeisha Payton?
Yes, ma'am.
Okay, now I found you. All right. All right, I'm going to put you in a breakout room waiting for Mr. Canine to come in.
Okay.
All right. Thank you.
Thank you.
Hi, Sandra. What cases are you here on today?
Good morning. I'm here for Calvary 231253 GC.
Okay, so you're covering for Old Cheese?
I'm here for Weber Nolsey's office, yes.
Okay. Nobody's here yet. So.
Okay. Generally, how long does the judge give for the other side to appear?
30 minutes.
30 minutes. Okay. Is it possible at the 30-minute mark if they haven't appeared, just because I have 2 hearings at 9:30? If you could just like make a note of that so that they could call my case.
We usually do.
Okay, thank you.
You're welcome. Hi, Allie.
Yeah.
All right. Good morning. Oh, sorry. I just muted you. If you can unmute yourself, please.
Hi, good morning.
Good morning. And then put you back out into the waiting room, waiting for the other party to appear, okay?
Also, waiting for my turn.
I can't hear you.
I hear you also.
Still can't hear you. Hi, Blake.
Good morning.
Good morning. You're here for Nationwide?
Yep.
All right. When the other attorneys appear, did you want to speak to them?
I'm sure. Yeah, we can do that.
All right. Nobody's here yet, but just asking.
Okay, thank you.
Yep. Hi, Aaron.
Good morning. How are you doing today?
I'm fine. How are you?
Good. Get some video going here. I'm with my clients, so we're all here for my side.
All right, I know the other side, Ali is here, but the attorney is not yet.
Okay, yeah, we're ready whenever the judge is ready.
All right, so you don't want to speak to the attorney?
We spoke last night.
Okay, so you're ready to go once the other attorney appears.
Correct, we're all set.
Perfect. Thank you.
Thank you so much.
Yep.
Let me see that. What?
Hi, Miss Francis. What are you here on?
Good morning. I am here on Crown Asset Management.
You're here for Mr. Canine on that?
Yes.
Is that the only case you're covering for him? On that one?
Unless you have others.
I mean, not Crown Asset, but he has 2 more for Synchrony Bank.
Oh, okay. Can you give me those names and I'll check on
Yep.
them?
Synchrony Bank versus Sharonda Young.
Rhonda Young. Okay.
And then Jermaine Tyler.
Okay. I will check on those.
If you can, because Jermaine's already here.
Okay.
All right. So
Thank you.
will. You're welcome. I'm gonna. Lakeisha's here also. Do you want to speak to her?
Sure.
Thank you. All right. It looks like Mr. Carmichael's here, Mr. Stempian, and Miss Corcus. Do you guys all want to go into a breakout room?
Sure.
All right.
Are we ready on Nationwide versus Bracken?
Judge, I'm sorry. It's the next file down.
Calvary versus White?
Samag versus El Talanicu.
All right, got that one.
Sorry.
So Sama versus Al Taliquani. Are we ready?
Yes, we're ready, Your Honor.
Good morning, Your Honor. May it please the court, Robert Figg on behalf of the defendant, Al Taliquani, who is also, I believe, president of Zoom.
Thank you. What are we doing today?
Your Honor, this is our motion, defendant's motion to set aside a default possession judgment. It was a possession judgment only that was entered by the court, as the court may recall, and it's indicated in our brief. Do you want me to argue the motion now, Judge?
If that's what's scheduled today.
Yes, absolutely. I didn't know. I just want to make sure I was telling you what
Yep.
the issue was. Sorry.
Yep.
Yeah, it's our motion again, Your Honor, set aside default judgment. This is a possession judgment for commercial property. Your Honor entered the default judgment. My clients actually were there. They appeared by Zoom. 2 prior hearings in this matter have been by Zoom. They mistakenly, and unfortunately in the Zoom world, I've even had it happen a few times where you think it's by, I mean, luckily I was able to determine it before, but you think it's by Zoom. That was a live hearing. The last one Your Honor had, they thought it was by Zoom. They appeared by Zoom. They actually raced over to the court that day, that morning to be there. Unfortunately, the court had already entered the default judgment. So the first thing we're asking the court to do is set aside that default judgment. We did attach an affidavit of Mr. Ali Al-Taqwani indicating those facts, Your Honor. So we are asking the court to set aside that default judgment. As far as the actual merits, this is a commercial lease. It's a 1-page commercial lease. It's attached. It was attached, obviously, to the original complaint. It's attached again to our motion. The complaint is for unpaid rent for several months, as well as for a water bill in a little over $4,000. The lease itself does not state, it's a 1-page commercial lease. Clearly, the parties did this. I know Mr. Speck didn't represent him. I didn't represent him. Neither side had an attorney, probably why the lease looks the way it does. And there's nothing in there as to utility bills, who pays utility bills, nothing in there as to water bills, nothing. I mean, it's very basic, has base rent of $1,100. They're claiming that a pipe burst, and therefore the water bill went up. There's, again, nothing in there who maintains anything in this lease. It doesn't state it at all. And,
Understood.
And the pipe burst, I mean, it's my understanding, not 100% sure, it burst somewhere near the meter. But again, there's nothing in the lease that says who pays that. They're trying to tag it to my client to say he's responsible for it. In fact, under my client had been in this property since 2020. The landlord had always paid the water bills. My client never paid one water bill.
Okay.
So certainly my client should not be paying the water utilities. The lease itself says it was for $1,100 rent. My client has always paid $700. This again goes back to around when COVID started. My client was paying $700. There's actually there was a text from the landlord referencing that the amount is $700. They may try to say, well, it's a statute of frauds issue. It has to be in writing. It is in writing from the landlord. And when there's a course of conduct, there's an estoppel issue that applies against the statute of frauds. There's case law to that effect that says if the parties have a course of conduct that they've always done, and this has been going on for 3 years, where my clients paid $700 a month in rent. So they've got an inaccurate number in there at $1,100. And they don't dispute that. I didn't see a response where they say, no, it's not $700. It's $1,100. The written lease does say $1,100, but my client's, the course of conduct, he's always paid $700 since this lease commenced in 2020, March of 2020. And we're going on.
All right, let's hear from the plaintiff. Mr. Speck?
Thank you, Your Honor.
As the court's aware, the defendant's required to show good cause as well as a meritorious defense. And also they would have to pay attorney fees as a condition to setting aside the default. Your Honor, the court.
I'm sorry, Mr. Speck, you cut out there a little bit. You said in addition, and then you cut out.
An award of attorney fees would be warranted under the court rule as part of the process of setting aside the default. In this case, Your Honor, the defendant was notified by the court to be there in person. I wasn't I believe he was notified at the first or the second hearing, whatever it was, to be in court, and then a court notice went out. So that, I believe that's not actually a good cause. And then the court waited on him a sufficient, he didn't get to the court. I think it was like 45 minutes later, but you had already proceeded. In terms of the meritorious defense, Your Honor, I don't believe they've shown a meritorious defense. The lease is silent on the payment of the water bill. This is a commercial lease. I don't know of anyone that in a commercial lease would require the landlord to pay the water bill. But having said that, this was a water bill for a 3-month period that was attached to the complaint. That 3-month period was just this last winter, where the building was not heated properly. The pipe burst, resulting in a 3-month bill of $4,000. If the defendant did not properly have the bill, there's nothing in his meritorious defense saying that, well, we had the building properly heated and therefore it wasn't due to their own fault that this pipe froze. We don't have any meritorious defense. So in terms of claiming the water bill, this is a 3-month bill, when in the past it was $20, $30. This is a $4,000 water bill that my clients had no control over because the building was not properly heated. The defendant was aware of that. He's not put a meritorious defense saying that, yes, the building was properly heated. In terms of the rent payments, there was, during COVID, there was some consideration given, but there's no signed writing agreeing that this would be continued on a continual basis between the parties. So the court was well within its prerogative, based upon our request, to follow the lease agreement, which is $1,100 a month for 4 months. And I think it was 5 months by the time we went to the hearing, if I'm not mistaken. And I think that there's no meritorious defense here. The rent is owed. There's no offset. There's no signed agreement between the parties altering that amount. And the water bill is based upon a frozen pipe that certainly my clients have no control over, and there's no meritorious defense saying, no, this, the building was properly heated, and therefore it's the fault of this pipe freezing and breaking is not ours as the defendants. I don't see that as being proffered to the court. Therefore, I'd ask the court to not set aside the default, to not set aside the judgment, to award my clients the $1,100 that has been posted into escrow, to be applied towards this, actually that would be for the next month. So we're now like 6 months into this. And I'd ask that the judgment to be maintained. I don't think they've met good cause or meritorious defense based upon what we proffered as the basis for the claim.
All right, Mr. Feige, response?
Yes, Your Honor. This is a complaint for possession for breach of a lease. So the lease, they want it both ways. They both want to say, well, it says, and they don't deny. I didn't hear any denial that it's been 700 since 2020. Did not hear a denial. They don't deny that it's been 700 for 3 years, $700 a month for 3 years. They don't deny it. And the lease itself doesn't reference who pays. It doesn't say the tenant pays the utility bill, and they didn't deny the landlord has been paying the water bill. The building is not, there's not much heat in the building. Apparently there's only like 2 vents in the whole building. We don't have evidence that it was a frozen pipe. I mean, that would be a factual issue. I'm not saying it was, I'm not saying it wasn't, but we don't have evidence it was a frozen pipe. But there's nothing in the lease that says the tenant is responsible for that bill. And that's what they're suing under. They're suing to evict him under the lease. And so therefore they don't have a basis to do that. And I do believe there's good cause, Your Honor, to set aside the default judgment. I get my client again, as I explained it, he thought by Zoom. The 2 prior had been Zoom. He did get to the court. I don't know if it was half hour, 45 minutes. I don't know. I can't answer that. He did say he got, as soon as he learned, because I think he got on Zoom that morning and they said, no, this is live. And he immediately got in his car and raced over as fast as he could. Unfortunately, it was after the fact and you had already entered the order. Right. But I do think that's good cause, given that he didn't just, that is unfortunately a mistake I've seen made in the Zoom world. So,
yeah, I'd like to say that's the first time I've seen that, but unfortunately we get it all way too often. Folks don't look at the notices nearly as closely as they should. And in today's new world, I think that is good cause. And I also think there's a meritorious defense because the lease is a terrible lease. So I'm going to set aside the default judgment. Fellas, you want to pre-try the case now? What do you want to do?
I think we just need to set it for trial, and I think that the court rule provides my clients entitled to an award of attorney fees as a condition to set it aside, Judge. We were there ready for
What are you
trial.
asking for?
$550 for the morning that I was there.
All right. Mr. Feig, any response to the $550 request?
Yeah, the only issue there, Your Honor, is this is a little different. I do understand the court rule. It does say attorney's fees on a set aside default. The only difference, a little different here, Your Honor, that's in the event, say somebody doesn't answer the complaint, I then have to prepare a default judgment. So I prepared documents that I normally wouldn't have had to prepare. Here, I understand counsel was there, but they would have been there anyway. That was a date for a hearing. So it's not that was a date that had he wouldn't have had to go on. He would have had to be there that day anyway to do that work. So I do understand the court rule does provide for it, but I think there should be a little bit of, I guess I would say, some discretion of the court here, only because, again, it was a date. It wasn't like he didn't answer the complaint and counsel had prepared a default judgment. Those are kind of the ones you often see for motions for default. So
Except now we have to come back again, Your Honor. So I believe the court rule is pretty clear. I think it has to be, but there has to be an award of something as a condition.
Understood. Mr. Feiga, I'm assuming that you were retained after the default was entered?
correct. Yes, sir. I came in after the default was entered. Correct.
Well, one of my simple rules is stupid has to hurt or stupid continues. And anybody that's in business that doesn't get an attorney involved when they're sued is not making good decisions. So that should cost somebody. So it's $550 attorney fees today. Gentlemen, would you benefit from any mediation? We've got a real low key, no cost mediation process going here if you'd like to try it, or I can give you a date.
Let's just get a date, Judge, and then I'd like an escrow order for him to pay the $1,100 in rent on a continual basis until we get this trial.
And Your Honor,
Any
I'd be
objection
okay.
to a continuing escrow?
No, I mean, I think it should be 700, Your Honor, but that's at Your Honor's discretion. But I don't have a problem with a mediation, Judge, if that's what the court would do. I just want to put that on the record. We may need some discovery, Your Honor, between now and I don't know when your next trial date would be, but.
Heather, are you looking at the calendar?
I am. I have lots of dates for us already.
Maybe something in September, then we can have a little written discovery period.
All right. I have September 11th, Monday, morning or afternoon.
Either's fine for me, Judge.
I'm okay. I got something in the morning, but I think it's going to get moved. That's the 11th, right? I think that's going to get moved. So afternoon for sure, but the morning, I'm not 100% sure.
All right, let's call it 9/11, 1:30.
Okay.
And written discovery until then. Anything else, fellas?
This is live.
This is live. Yep.
Thank you.
And I will
Yes.
enter an escrow order. I'll enter an escrow order of $1,100 per month. We can always hash out what amount of that might go to the plaintiff and what might not.
And that would be going for, there's 1,100 in the escrow right now. That'd be 1,100 going forward for the next month.
Correct, counsel.
Okay.
Correct, counsel.
Thank you.
And I'm assuming the rent, whatever day of the month the rent was due. If the rent was due on the first of the month, then that's when the escrow is due.
Okay. I believe it was. Let me just
Anything
check to
else?
make sure.
Thank you, Judge.
Yep.
All right, have a good day, gentlemen.
Thank you, Judge. Thank you. Have a good day.
Heather, you got anything else?
Yep, they are ready in National Mutual versus Amber Brecken.
Appearances, please.
Good morning, Honor. Blake Carmichael for Plaintiff Nationwide.
Behalf of the defendant and third-party plaintiff Amber Bracken.
Good morning, Your
Hey,
Honor.
counsel, I cannot hear you.
Okay,
Can you increase your volume some way?
I can try. Is it still bad, Judge? Is it still too quiet?
That's a little better, I think.
Let me just get myself closer to the computer. Maybe that will assist us here.
Okay. Ms. Corcus, your appearance?
Good morning, Your Honor. Christina Corcus appearing on behalf of third-party defendant Progressive.
All right, today's date and time set for pretrial, correct?
Yes, Your Honor. And if I may briefly, we had an opportunity to talk this morning and some
Good.
facts have arisen that I believe this case is going to be dismissed. So if we could maybe adjourn
Okay.
this even like a week. I have an adjuster that I'm not gonna be able to call and get hold of right this second. But if you give me even 7 days, can just adjourn this, I believe we'll have a
All right.
entered order of
Heather, when's
dismissal.
our next civil date?
It is August. I just had it. Sorry. August 15th.
Let's put you on the docket for August 15th. You can always dismiss it before then.
Is that a pretrial or what is that? Just so I know.
Sure, we'll just call it another pretrial date. 9 o'clock,
Yep, sounds
August
good.
15th. Okay, does that work for everyone?
Works for us, Your Honor. Thank you.
Okay. Have productive days.
Thank you.
Heather, what's next?
That's it for now.
Thanks.
Hi, Heather.
Hello.
Mr. Tyler, we're just gonna get a scheduling order.
And what does that mean? I'm sorry.
Just open up discovery for maybe 60 days. He says he doesn't have any knowledge, so we'll send him some statements.
So it's just, so it's, hold on, let me ask. All right, when the judge comes back out here, we'll handle that. Okay.
Okay, and then Miss Young did not appear.
Not yet. It wasn't until 9 o'clock.
Oh, okay. Okay.
But what were you talking about, Mr. Canine?
Mr. Canine is no longer at the law firm.
Which is the one that you're at right now, right? Is that what you're talking
The
about?
one I'm covering for.
Yes.
For Rouse,
Okay.
Rouse Sturm. Yeah. So it's Alexander Papa, who is the attorney of record or who is the attorney for Rouse Sturm now.
Yeah, we will have to have something, I'm sure, only because now that we're doing this my file, or they'll need something.
Okay, I'll have them send in a letter or something.
Okay, thank you.
Because I think he was using jabs.
Oh, where did Mr. Did he hung up? Where'd he go?
Oh. If you want to give us the new pretrial date, or does the judge have to open up discovery?
I think that's what has to happen.
Oh, okay.
Miss Francis?
Yes.
Oh,
Sorry, which
yeah,
Francis?
sorry, which one?
Sorry, I was talking to, is it Naviat? I never say your
Not
name
bad.
right.
Nav.
It's okay.
All right. Mr. Tyler's back. Okay. So do you want to do 60 days, you said, for discovery?
Yes, please.
Okay, so we have a September 19th day.
Perfect.
Discovery. All right. So that one's all set.
At 8:45.
So
Yeah, that's good.
what do I do to get the documents to review all the documents and the master bill of sale and stuff, the things that's pertaining to this account?
You will have to ask for what you want to according to the court rules, sir.
Pardon me?
You'll have to ask for them according to the court rules.
According to the court rules?
Mm-hmm.
Okay.
Okay. Thank you.
All right. So are we finna have a hearing, or the hearing is over?
The pretrial is reset to September 19th at 8:45, and discovery is open in that meantime.
All right.
Okay. Thank you.
So that's it?
Yes.
All right. Have a good day.
You too. Heather, I am still on here. I just had another 9 o'clock since I didn't know about these.
Oh, okay. Yep.
So in case I don't answer, I might be on the record on those.
Oh, okay.
Thank you.
Thank you. Hi, Mr. DeLuca. What are you here for?
Good morning. I'm here on Catholic Vantage Financial Credit Union versus Stephen Lowe.
So you're here for Mr. Holzman's office?
Yes.
Okay. They are not here yet.
Okay. I don't expect anybody, but you never know.
That's right. Hi, Miss Toma. What case are you here on?
I'm here on case number 092110. It's Ford Motor Credit Card Company versus Dennis Carter.
So are you here for Tricia McKinnon?
Yeah.
Okay, thank you. Hi, Mr. Neal, what are you here for?
Good morning. Here for Catholic Vantage Credit Union versus Stephen Lowe, here for plaintiff.
Okay, I have Mr. DeLuca here for that.
Oh, interesting. If he's here, then I guess he's probably going to handle it then.
Right, Mr.
So,
DeLuca?
I will send him a message right now just to make sure he's on it, and then I will log off if he is.
All right, thank you.
Thanks.
Sandra, it looks like Mr. White did not appear.
Okay.
So if you want to send in your default.
It was actually scheduled for a motion for summary disposition. Are we able to, I was going to request that the motion be granted.
All right, yep, I'll let the judge know.
Okay, and there is a proposed order attached to the motion. Do we need to put that on the record or am I all set?
We'll ask the judge.
Oh, okay.
Appearance on Calvary versus Thomas White.
Good morning, Your Honor. Sandra Francis on behalf of the plaintiff.
Good morning. I understand Mr. White did not appear today.
Yes, Your Honor.
All right. After a hard-fought argument, your motion is granted.
Thank you, Judge.
I am signing the order.
Thank you, Judge. Have a nice day.
You as well. Heather, you got anything else?
Nope, still waiting for all of our 9 o'clocks. Hi, Denise.
Hello.
Hello. Let's see. Kayla, did you want to speak to Ms. Carter?
I mean, I can.
All right.
It's fine.
Hi, on the iPhone. What's your name, please?
Oh, Sharonda Young.
All right.
Yeah.
Ms. Francis.
Why is it my name?
All right, I'm going to put you in a breakout room waiting for the attorney to speak to you, okay?
To me?
Yep, to you.
Ms. Young?
Miss Young.
Oh, okay.
All right, hold on.
Okay.
You can send me in, Heather. Sorry.
I'm sorry, what was that, Ms. Francis?
You can send me into the breakout room.
Okay,
Sorry.
thank you.
Thank you. Hi, Heather.
Hello.
We're just going to get some, she wants to send us some paperwork, so we're just going to possibly do the same thing, discovery until 9/19.
So pre-trial on 9/19.
Yes.
Okay, pre-trial 9/19. Do you want 8:45 again?
Yes, please. Thank you.
All right. Did you
I'll
want
try
me?
to go back in there if she is still in there.
Yep, she is.
Okay, thank you.
Thank you. And then you're all set, right?
Yes, thank you.
All right. We'll see you next time.
All right, bye.
Bye. Mr. DeLuca, do you want to call your case? Because it looks like Mr. Lowe failed to appear.
Sure, yeah, thanks.
Hold on.
Which one you got, Heather?
Sorry. This one is Catholic Vantage Financial versus Lowe.
Yep. Appearance, counsel.
Yes, good morning, Your Honor. Stephen DeLuca on behalf of the plaintiff Catholic Advantage Financial Credit Union.
And what do we got today, counsel?
Today's the hearing date for entry of a default judgment in this claim and delivery
Yeah,
case.
claim and delivery. Yep, yep. Okay, and we have not heard from Mr. Lowe. I'm assuming you have not either?
No, I haven't.
All right, yeah, why don't you submit your default? You can do that electronically if you want to get it quick.
All right, we'll do. Thanks. Have a good day.
You as well.
Bye-bye.
Good morning.
Hello, good morning.
All right, let me just check you in.
Hey, she's getting you worked out, sir. If you have any questions, you're right here at the desk, okay? Okay. All right. Okay, thank you. You're very welcome. Thank you.
Kayla, did you guys come to an agreement or what's going on?
So we're gonna continue to deny the objection, but we did come up to like a payment arrangement. And we're gonna ask the court to enter into an order for.
Well, let me bring the defendant out and then I'll let the judge know to come out, okay?
Okay, perfect. Thank you.
Yeah.
Appearances on Ford Motor Credit versus Carter, please.
Ford Motor Credit Card Company. I'm plaintiff's attorney, Kayla Toma. 86304 is my P number.
Thank you. Denise Carter, you have a camera. Activate it, please.
Okay, hold on. I'm trying to get to it. How do I wait? Oh, okay. Hold on, Judge. Be patient with me, please. Okay.
Yep.
All right. Okay.
There you go. Good morning.
Good morning.
All right, counsel, this is defendant's objections to garnishment, correct?
Yes.
All right, let me get to that form, Ms. Carter. All right, you said that the garnishment is improper because of the statute of limitations. Explain what you mean by that.
Well, because it's been 14 years that this has been going on. And so I'm just taking it that it's just been, too long. But then I talked to the attorney and she told me that, they can just keep renewing it basically forever, So right now I'm just ready to try to get it resolved and, move on.
Okay. So it sounds like after just speaking to the attorney, you understand that I'm going to have to deny your objections.
Yes, yeah.
Okay. All right. Counsel, I'm assuming you'd be willing to go into a breakout room and discuss possible settlement.
We actually, in anticipation of your move, we already came to some sort of agreement.
Good.
The terms of the agreement is $50 a month starting August 11th. And on the 11th of each month thereafter, I was going to ask the court, Your Honor, to enter an order to that extent for installment payments. If you would like to.
I'll tell you what, if you want to email me an order, I'll sign one.
Okay. And can I have your email?
Yeah, we'll chat that too. You're going to email it to the civil department.
Okay, perfect.
We'll get that out today. Ms. Carter, any questions?
No, the attorney explained everything to me. And so,
okay,
we're good. And to make sure that that we get this resolved, I've agreed to automatic debit payment coming out of my personal checking account.
Good, that's easy on you. Okay, good luck.
Thank you.
Counsel, I'll get that signed as soon as they put it in front of you, counsel.
Okay, I appreciate it. Thank you, Your Honor.
Have a good day, ladies.
You as well.
Maria, what are you here for, please?
Hi, I was the interpreter requested for the Russian language. They did not state the name of the defendant or plaintiff that I'm supposed to be helping out today.
Sure. Do you want his name? I will spell it for you. He's on already. He's on Zoom right now.
Okay, cool. And this is a pre-trial, right?
It's for civil, yes.
Okay. 1 second. I will take down his name now. I'm ready.
The first name is AKH, M as in Mary, AJON as in Nancy. The last name is IGA, M as in Mary, B as in boy, ER, D as in David, IEV as in Victor.
Thank you so much. Okay. Great.
So I don't know, did you want to speak to him now? But
does he have an attorney with him or is he?
Nope, he doesn't have an attorney.
Okay, I can speak to him now. I'm not quite sure how like the Zoom court meetings usually go. I usually do in person, but yeah, I can introduce myself to him. Здравствуйте, господин Ахмажан. Я буду вашим русским переводчиком сегодня.
Здравствуйте, да. Okay.
И, господин Ахмажон, можно вас спросить, какое у вас сегодня дело будет?
Сегодня
Да.
насчет вот этого кредита, вот, который Discover я получил вот этот, и они год почти они не снимали у меня ничего, я автоматически делал, они ничего не снимали, и потом они меня дали на суд. Ну, было такое дело, там я, когда в прошлом году, я когда оформлялся на, как это говорится...
Кредитную карточку?
Не кредитную карточку, хотел дом купить.
Ипотеку, окей.
Компания, ваш кредитный рекорд, они почистят, и потом вы можете получить деньги, сказали. Я подключился к этому компанию, 3 месяца платил им, они сказали, ты не будешь платить тому компанию, который кредитору, мы сами будем все это решить, и дальше будет, мы будем, нам будешь платить, а им не будешь платить. А 3 месяца я платил им, и 3 месяца эти тоже у меня снимали все. Потом я сказал, это cancel, сделал тот компанию, все, они все деньги вернули, а эта компания потом тоже перестала, что у меня снимать, и после этого вот эта история начался.
Окей, хорошо, окей. Спасибо большое, господин.
Я вот это написал все и отдал, документы отдал сюда тоже на корт вот этот, и потом один письмо отправил банку туда.
Окей. Хорошо, спасибо, я теперь понимаю. Окей, будем ждать судью.
Да.
Hi, Jen, what are you here for, please?
It's me?
No. Jen, what are you here for?
Just here on behalf of Belleville Manor.
Okay. Mr. Landman, are you here for Belleville Manor?
Yes,
Okay, thank you.
yes, I am.
All right. Hi, Tiffany. You are here for Jeffrey Beers?
I am, yes.
Okay. So I'm not able to pronounce the name, but Mr. Akmajan is here with an interpreter. So I'm going to put you in a breakout room and if you get so you guys can talk, is that okay?
That's fine.
Okay.
Thank you.
Yeah. Desiree, what are you here for, please?
I'm here for the case with site 324 Green.
What are you here for? I mean, who are you here for? Are you here for Belleville Manor also?
Yes, I'm the community manager.
Derek,
Hello?
what are you here for, please? Derek,
Yes, hello. I'm sorry. I'm just trying to get this to work. I'm sorry.
that's fine. What are you here for?
I'm here for a meeting with Honorable Judge Oakley.
For what?
It's for a issue with a Yes Communities for Charles Green, who has passed, and all other occupants in this.
Oh, okay. All
home.
right. I'm gonna put you in a breakout room with the attorney, okay?
Okay.
Mr. Land, you want all the managers and everybody
Yes,
too?
please.
All right. Oh, thank you, attorney.
Heather, when everybody gets back, we're ready for Judge Oakley.
All righty.
Oh, yeah, this
There you
one.
go. Okay.
Thank you.
You're
sir.
very welcome.
Thank you.
Tiffany, do you need to go in front of the judge as well?
We have a settlement, so we can put the settlement on the record, or we can submit paperwork to the effect of the settlement, whatever is best for the court.
You can just send in the settlement, email that in. Do you need our email address?
Yes, please. And so with that, do you want us to do that as an entry of a consent order, or do you want us, because normally what we do is we send it to the defendant to have them sign it, and then we sign it, we send it to the court. You want us to just present it as an order?
I don't know. I honestly don't know. I mean, did you guys come to an agreement for you to sign his name, or?
No, we didn't talk about that.
All right, well, then we can just wait for the judge to come out and talk to him.
Okay, sounds good. Thank you.
You're welcome.
Oh, thank you for the email as well.
Looking at that.
All right, appearances on Discover versus Diva.
Good morning, Your Honor. Tiffany Williams on behalf of Discover, P number 74809, standing for the attorney of record.
Thank you. And I understand we have an interpreter.
Yes, my name is Maria Arnion. I will be the interpreter for Ahmadjan Igamberdiev.
All right, do you have a camera, Miss Arnion?
Yes, 1 second, I will turn it on.
Thank you.
Mhm.
Thank you. Would you raise your right hand for me, please?
Yep.
Do you swear or affirm that you will accurately translate between English and Russian and English so that myself and the gentleman and counsel can discuss this file today?
Yes, I solemnly swear.
All right, would you let him know what we talked about?
Yes, Your Honor. Yes, Your Honor. We reached a settlement on this file where the defendant agreed to make a down payment of $1,000 within 30 days and then monthly payments of $400. We're going to reduce this to a consent judgment in which we're going to send to him for him to review it, sign it, send it back to us so we can present it to the court.
Окей, значит, мы пришли к договору с ответчиком. Мы договорились, что он будет оплачивать $1000 предварительный взнос, и потом в течение 30 дней, и потом ежемесячно $400. И мы это уменьшили к решению согласия. Мы отправим ему документы, чтобы он мог просмотреть, подписать и отправить обратно к нам, чтобы мы смогли подать эти документы в суд.
Да.
Yes.
Sir, do you have any questions about the way this process works?
Господин, у вас есть какие-то вопросы насчет, как этот процесс работает?
Я думаю, это все понятно. Они мне пришлют письмо, я подпишу, потом буду платить вот это $1000, и потом остальные $400 каждый месяц автоматически буду платить.
If I think I understand it correctly, I will be mailed over some documents, which I will sign and send back, and then I will be paying the $1,000 payment, first payment, and then I'll continue with automatic payments of $400 automatic.
That is correct.
Sounds like the terms, counsel.
Это верно.
Anything else?
Есть какие-то другие вопросы?
Нет.
No.
Спасибо.
Thank you.
Good luck.
Удачи.
Thank you. Thank you, Your Honor.
Thank you.
Ms. Arnion, thank you.
Thank you
Thank
for
you, Mr.
using
Moore.
our services. Bye-bye.
Bye-bye. Спасибо вам тоже.
Пожалуйста, всего доброго.
До свидания.
До свидания.
Все, можно выйти, да?
Да, можно выйти.
Heather, what do you got?
Next one is Belleville Manor versus Green.
Appearances, please.
Morning, Your Honor. For the record, Daniel Landman, P35797 on behalf of Belleville Manor.
Good morning, counsel.
Morning.
And do we have Charles Green?
Your Honor, Mr. Green is deceased. The occupant is a gentleman named Derek Gabbard, who is on Zoom.
All right. And I've got an attorney for defense, Attorney Cooper. Have you had any contact with Attorney Cooper, counsel?
No, she was involved in negotiating the conditional dismissal order, Your Honor, but I have not heard anything from her since, and Mr. Gabbard apparently has not spoken with her either.
All right. Mr. Gabber, if you have a camera, please activate it.
He did have, when I was in the breakout room, he was visible.
Did we lose Mr. Gabbard?
It looks, oh, he's coming back in right now.
Keep getting kicked out. Well, counsel, what's your pleasure? I don't know if he didn't want to talk to me or if he's having technical
No, he
difficulties.
absolutely did want to talk to you, Your Honor. So it must be a technical issue.
Well, I'm okay giving him a few minutes if you are.
I'm okay with that.
Okay.
Hey, Mr. Gabbard, do you have your video also?
What's that?
Your video, yeah, okay. The judge will be back in just a minute.
Okay, thank you.
Yep, you might just want to sit still while you have service.
Yeah, it keeps cutting. This Zoom stuff's ridiculous. I'm still filming.
All right, Mr. Gabbard, you made it back.
Yes, sir.
All right.
Hello.
Okay. So I understand that you are currently a resident at the unit and that Mr. Green has passed on.
Yes, sir.
Okay.
I'm not really a
And
resident.
I also
I'm not.
understand. Go ahead.
I'm sorry. Okay, yeah, I'm not
That's
really
right.
a resident. I just come to maintain it and show the property when someone's interested in it.
Okay. Show the property. Explain
Yes,
that to
because
me.
I have it for sale. I have it listed online, and I have the a for sale sign posted on the home itself with
Okay, who
my
owns it?
phone number. What's that?
Who owns the home?
I'm sorry. I own it. It was
Okay,
left
you
to
own
me.
it, and I'm sorry, say that again.
Yeah, when Charles has passed away, my uncle, it was left to me in his will, and
Okay.
I've been trying to clean it and sell the home to get a new home.
Okay.
I've been
Okay,
staying with my
gotcha.
brother for the time being.
Your Honor,
Okay,
this
I
was
think-
a termination action. Ms. Cooper assisted the defendant, and a consent judgment was entered into for conditional dismissal. The consent order for conditional dismissal. Sorry. Under the law and under a mobile home termination action, the defendant would have a brief period of time to vacate and then 90 days to move or sell the home. And that was reflected in the conditional dismissal order. Mr. Gabbard was supposed to vacate by February 6th, and he had 90 days to move or sell the home from January 31st, which took us through the end of April, very, very beginning of May. Mr. Gabbard claims that he has vacated. However, he acknowledged to me when we were speaking in a breakout room that there's still furniture in the premises. So that suggests to me that perhaps it is still being at least partially occupied. In addition, the home hasn't been sold. Mr. Gabbard apparently is requesting an indefinite amount of time to sell the home. We want to enforce the law, which provided that the home should have been sold by the end of April or very beginning of May. Because the home hasn't been sold, because there are still belongings in there, we are requesting that the conditional dismissal order at this point be set aside, that a judgment be entered, and that an order of eviction be entered concurrently.
Okay, thank you, counsel. Mr. Gabbard, response?
Yes, sir. Yes.
You have any response to that?
What's that?
What the attorney just told me.
Yes, what's happening is I'm selling the home with the furniture because I don't have the money to get a U-Haul to tow the furniture out, and it's just to show the home off to make it look more homely as well. So when it's shown, it doesn't look so empty. So I have a couch or two in here and to show the home off.
Okay, so why should I not give counsel the relief he's requesting?
Because it goes on my record, and then I won't be able to get a new home and need the eviction out of my home, because then I'll be homeless trying to get another home. I've been working on getting a new home, trying to sell this home, and every person who's tried to get the home has been denied and hasn't been able to come forth with buying a home. So I lowered the price on it, and I'm trying to get rid of it as soon as possible.
Your name's not even on this lawsuit, so anything I do on this lawsuit is not going to affect your ability to do anything.
Okay.
Understood?
Yeah, I understand that. Yes.
Okay. So you agree with what counsel told me, that you had, by agreement, you had 3 months to sell the home, and that was up in April?
Yes, I understand that. Yes, and that's why we are here today, because I'm trying to get another extension that way. So I have a couple of people interested in the home, and I'd like to sell it before it gets any worse, and like to, vacate and sell properly.
Okay. All right. Well, there's no legal, or at least I haven't heard any legal reason why Belleville Manor's request should not be granted. I'm assuming you gentlemen had a chance to talk in a breakout room. If there was something you could offer Belleville Manor so they'd give you more time, that was already discussed, I would assume.
No, it was not.
All right, well, can you buy, are you in a position to offer them money to buy some time?
No, so what I'm doing is I'm on Social Security disability, and I'm paying the
Okay.
lot rent on time and the heat and electricity bills, so I can show the home off with lighting and show that the AC works and everything.
All right,
But I'm
anything
paying the
else,
lot.
council?
I'm paying the lot right on time every month.
Council, anything else?
No, Your Honor, Mr. Gabbard is required to continue paying the lot rent as a condition of the home staying there to give him the initial 90 days. The bottom line at this point is he had plenty of time to lower the price. I'm even more concerned by the fact that he's saying that the existence of a judgment might affect his ability to find another place to live. One would have thought that would have happened by now.
Motion is granted.
Yes.
Good luck to you, Mr. Gabbard.
Okay.
Council, you can submit an order electronically if you'd like.
Thank you, Your Honor. We'll do that.
Heather, you got anybody else ready?
No, I do not.